The Law of Persons. Part 1. Slavery. Slaves were the most vulnerable people in society of Roman society. A relatively small number of slaves resided in Rome throughout the early Republican era, but starting in the middle of the 3rd century BC, the slave population quickly increased. By the end of the Republic, slave labor had become the primary source of income. Urban slaves received better treatment than rural ones and were released from slavery more frequently. Causes for slavery. Being birthed from a slave woman. Capture in war. As a punishment, from a decision of the court. For doing illegal things. A free woman having a sexual relationship with a slave despite her husband's opinion. Is a slave a person or a property? A slave was considered to be a person and property legally existing as the object rather than the subject of rights and duties. As he was the property of his master, he lacked legal capacity, and this theoretically entitled the master to govern the slave as he pleased. 1. The owner had the rights over the slave's body. 2. Slaves did not have any rights or duties. Limitations to slave owners. The practice of considering the murder of another person's slave dates back to Lex Cornelia in 81 BC. Starting in 79 AD, the Lex Patronia made it unlawful to use slaves in animal combat without a magistrate's permission. The ability to kill one's own slave was outlawed unless a Hadrianian magistrate gave their consent. Slaves who had been abandoned by their owners were given freedom by Claudius. When his owner mistreats him, the slave cannot sue. But he could tell a magistrate about it. After taking into account the circumstances, the magistrate had the right to order the owner to sell the slave to a more compassionate buyer. A slave had no legal standing in Roman courts, was unable to enter into a valid marriage, and their children were automatically the master's property. Contracts regarding slaves. The master is legally entitled to the profits of any agreements a slave makes with third parties. A master might be held accountable for the wrongdoings of his slave due to an actio noxalis. When a delict was brought against a paterfamilias for a wrongdoing by a son or slave, noxal surrender was a provision of Roman law. The defendant had the choice of either paying partial damages or giving up the dependent. If someone commits a civil offense against a slave, he should pay compensation to the master. Releasing from slavery. Formal ways. By a formal announcement by the master in public and before a higher magistrate, usually a praetor, that the slave was free. After the enrollment of a slave as a Roman citizen by the censor, according to the master's request. Under his master's will. When a master asked his successor to release a slave. If that slave was made free, the man who released him became his patron. Informal ways. When a master in the presence of his friends declared his slave to be free. When he expressed such a wish in a letter. When he shared his table with his slave. Manumissions made in the time of Christian emperors in front of a priest. By naming as someone's guard. By adopting. Naming as a successor. Other laws regarding slavery. Manumissions limited the number of slaves that could be freed at one time. A person under the age of 20 could only manumit a slave if he went through the regular legal process. If a master manumit his slave in order to defraud his creditors, the manumission was invalid. Certain slaves who were manumit could not become full Roman citizens but would instead become members of a lower class of freemen. Classified all freedmen into two classes according to their mode of enfranchisement.